Good morning. Thank you for being up so early to join us. I took very seriously Professor DeHart's warning or guidance there to be on time, so we will get started right away. Thank you for staying with us. My name is Caitlin Fennessy, and I am the Chief Knowledge Officer at the IAPP. For those of you who know me, you'll know this is my favorite and longtime topic, the future of global data flows. So really excited, particularly to talk with such a thoughtful group here about the topic. So let me introduce each of them to you this morning, although I suspect many in our audience are quite familiar with our panel here. Going from this side to that side. I'm not going to do left and right and get it wrong in front of you. Kathy Herman Stokes is the acting director of the U.S. Department of Justice, Office of Privacy and Civil Liberties. Kathy's office is responsible for helping to ensure that the Justice Department in the U.S. complies with the Privacy Act, the E-Government Act, and other privacy-related laws and policies. Perhaps more relevant even to our panel, Kathy has long participated in international negotiations related to harmonizing the high standards of data protection, privacy, and civil liberties in the law enforcement and commercial spheres. It's an area I had the pleasure of working with Kathy for many years. Sitting next to Kathy, we have Ralph Sauer. Ralph is the deputy head of the International Data Flows and Protection Unit at the European Commission's Directorate General for Justice. He's responsible for data flows related as well to both the commercial and national security spheres, and worked for quite some time on the original Privacy Shield negotiations, and also played a leading role in the negotiations of the just announced transatlantic data privacy framework. He's done a lot of work on the adequacy determinations with Japan and Korea, and led the work on the Commission's new standard contractual clauses. I had the pleasure of meeting Ralph. We were just talking about this, I guess, back in 2015 during those original Privacy Shield negotiations. And our goal is that those are the only 2 times we say Privacy Shield during this talk, but we'll see if we get there. We certainly want to look a bit more broadly today. Sitting next to Ralph, we have Joe Jones. Joe is the Deputy Director in the UK government's digital ministry, all right, but it's a more fun title, DCMS, the Department for Culture, Media, Sport, and their digital culture, media, and sport. There we go, which sounds like the most fun ministry in the entire UK government. His teams are charged with developing and delivering UK policies on international data flows, and prior to working at this amazing ministry, Joe worked on similar issues for the UK Trade Ministry and worked on privacy as a tech lawyer in private practice. Last but far from least, our colleague Hiroshi Miyashita is professor of law at Chow University in Japan, and worked previously on the Japanese Personal Information Protection Act in the Cabinet Office of Japan. He has contributed to Japan's adequacy decision with the EU, and has been involved with several international fora, such as Apec, the OECD, and the Council of Europe, some of which we will talk about today, and just delighted that he can be with us, since his flight was a bit longer than the rest of our travel here. All right, with those introductions, let's kick off. So as I said, while I think that transatlantic data transfers have long been in the spotlight, perhaps even led to much teeth gnashing for some of us here on the stage, we all recognize that data transfers today are not a bilateral challenge. They are much, much bigger than that. They are a huge multi-party, frankly, I would say mess at this point in time. So I think it's worth thinking about how data transfers are addressed much longer term, and I have the pleasure of asking the questions, and the colleagues sitting here have the incredible challenge of figuring this out from the policy front. So I wanted to kick off by saying that at the IAPP, the International Association of Privacy Professionals, where I work, we do an annual governance survey, and one of the questions we ask is about privacy professionals' biggest challenge. In our last survey, they reported overwhelmingly that data transfers were their biggest challenge. There was no close second. It was far and away the biggest issue. So just to set the stage before we kick off, I wanted to ask each of you, in a word or a few words, should facilitating international data transfers more effectively be a policy goal?
Okay, can you hear me? Okay, it's working. So yes, absolutely. Facilitating international transfers of data is mission critical to digital services that companies provide to get citizens what they're interested in. They help governments get the data they need to provide services to the public and also to protect the public. So we need to make sure that we have these critical data flows. The difficulty, though, is you need to have a strong, robust privacy civil liberties framework surrounding those data flows. And we're going to get into a lot of options for that, and I know it's all very confusing for companies trying to figure it out. But the good news is that privacy is being addressed now in a lot of different forums. So the G7, the G20, OECD, the TTC, the US-EU Trade and Technology Council, privacy is being addressed in a lot of different forums. So hopefully over time we'll be moving toward some sort of framework that's easier to navigate for companies. That was more than one word, sorry.
Okay, then I can be shorter and build on that. I think obviously facilitating data flows is a worthy policy goal, and so is, and I think that was rightly pointed out, the effective protection of data when data travels. And you, at the outset, referred to the title of the department I'm working for, which is International Data Flows and Protection, so I think it sums it up. That's what we want to do and what we're working on.
Well, the answer is yes. You know, we don't have this discussion about international flows of finance or money. I mean, that's taken as a given. And if anything, over the course of the past 2 to 3 years, it should be a given that personal data should be moving freely and safely, to Ralph's point, should be protected, but it should be moving across borders because that is what helps us connect with family, friends, and loved ones. It's what helps us do online banking. It's what helps us navigate around the world and in countries and cities that are not familiar to us. So yes, of course.
Yes, I just would like to echo other panelists. So international data flow is essentially a top priority in the Japanese political economic agenda next for the decade. After the adequacy with the European Commission, we see how we can realize data-free flow with trust, DFFT, under the Japanese initiative. So how can we ensure trust in data flow, including both EU regions and non-EU region? That is a political economic top agenda in the Japanese society.
Thank you so much. And I guess that might seem a silly question, but it does occur to me sometimes that perhaps some of us come at this from different perspectives. Maybe some think it is working well. So I think it's nice to set the stage knowing, okay, we all certainly agree it needs some improvement. So Hiroshi, I wanted to ask you a question to kick off, and I'll direct questions to certain folks here, but anyone should feel free to jump in, and look forward to your questions. I hope you'll have some at the end for us. In recent years, we've seen countries around the world adopt new data protection laws with data transfer rules or restrictions, including China and Brazil, and likely soon India. How do you think new global players in data protection law shift conversations on international transfers, if they do?
Yeah, thank you. And I think the newcomers such as China and Brazil and other Asian regions particularly have a great advantage in creating a new data protection framework by reflecting the best practices, existing best practice particularly in the Atlantic Ocean as well as the Pacific Ocean. At the same time, they have been building the data privacy framework based on their own political strategy or economic strategy. For instance, China has been pushing data localization law, and which certainly reflects their initiated trade agreement, RCEP trade agreements. But my understanding of these new legislations all stands on the European digital ground. For instance, Chinese law, new Chinese law provides individuals data portability right based on the GDPR. So they all stand on the common ground based on the GDPR. They always reflect European inspiration.
All right, actually, thank you. As I go along here, I'd love other thoughts on that question as well, if you'd like. But Ralph, Hiroshi's answer raised the question that I wanted to pose to you. And kind of relatedly, we've seen countries around the world take inspiration from the EU's approach. And before our panel, I counted up the number of countries that have put in place their own adequacy powers, and I counted over 80 countries now have a legal regime that includes an adequacy framework. Some have exercised it, some have not, but that's a lot that can do these kind of bilateral one-on-one approaches. So how does that affect the EU's approach to data transfers looking forward? Does the EU intend to scale or shift its own approach in light of these new entrants?
So, I mean, first of all, I think it's an encouraging sign that this instrument is being picked up also in other parts of the world. I think it reflects the benefits that come with adequacy. It's the one tool which is the most comprehensive one in terms of opening, let's say, the gates to free and safe data flows to an entire country, to all the companies, for instance, in another country. And I think in that it's very different from some of the other transfer instruments that we're probably going to talk about that are necessarily sort of more company by company, be that contracts, be that certification. So I think it has an important role to play. It's also interesting, by the way, that not only are indeed many countries around the world endorsing that tool, putting it into their system. Sometimes they call it whitelist, sometimes they call it something else. But beyond that, we see also a number of countries that have started to recognize each other's adequacy findings. So there are countries that simply rely and automatically incorporate into their system the adequacy findings of certain other countries. And that's interesting. It creates, in a way, a network effect. So with one adequacy finding, you might not, as I said, open the gates to the free flow with respect to one country, so in one bilateral relationship, but with respect to 2, 3, 4 other countries as well. So all of this is to say that also for us, it will remain one of the central transfer tools. Also, by the way, and because beyond what it does in terms of, based on a thorough assessment, opening the free flow of data, it also does something which we value a lot. It opens a channel of communication, it opens a dialogue with a third country. Because we always say adequacy is not the end of a process, although it is a process which takes time. And so once you get there, you're quite happy that you have reached it. But it's also the beginning of a process in the sense that following that, we are usually engaged with those countries. We have a dialogue, we have a review at some point where we discuss how things are going on both sides. And particularly with countries like Japan, where we have a mutual adequacy arrangement, I think that makes this a particularly valuable instrument. So it will remain one of our most important tools. You can always improve. You can always make it better, make it more efficient, and we are thinking about what we can do For instance, in terms of transparency, many people don't know that there are documents out there which in advance tell you, for instance, what are the standards to apply. There's the adequacy of referential from the European Data Protection Board. There's what they call the European Essential Guarantees, which are sort of the principles, limitations, safeguards that we are looking for when it comes to government access. These documents are out there. You can find them on the EDPB webpage, but probably it's not the easiest thing to do. So we want to do more on our website to have more information there on the standards, on the procedure, on the type of information that we're looking for from countries. So certainly there is something to be done here. If scaling up means that can we have within a couple of years, I don't know, another 10, 15 of these adequacy findings, I don't think so. It's something which every time it's a process. You need a thorough assessment because of the particular benefits. It essentially means treating another country as if it was part of your own internal market for the purposes of data protection. So to really get there, you need to well understand the other side, and certainly that means you have to focus a bit. We had in 2017 a communication where we have set out a bit our priorities and the criteria that we want to apply to engage on adequacy, and that's what we have done. We have engaged with very important partners, important in terms of data flows in particular, like Japan, like Korea, the UK, the United States. And that I think will be the same for the future. And the last word, it's a very important tool. It will remain one, but of course there are other tools that need to complement it because of what adequacy is about. And I think also in these other 50-something countries outside the EU, it means finding something which is very comparable to your own system. Of course, this will never be the case everywhere, and therefore you need tools that can bridge differences in data protection regimes. My view, and I think our view, is that model contract clauses, and we'll get to that hopefully, are a very important complement to that, and in fact they are the tool on which most data transfers take place from the EU. So that's another area of work. We have recently modernized, and we will certainly see what can be done to also make this a more global instrument.
Well, thank you. I'm gonna keep you on the spot there for just 1 second because, you know, as I look at this landscape and think about our panel here today, I guess my question or what I've thought about is it problematic then if you have 50 different adequacy lists when we think about global data transfers? Is the goal that they would all harmonize around one list? Is it problematic if they don't? Any thoughts on that when we think about global flows?
Yes and no. I mean, I think you naturally, because of what I just said, I mean, it's not just a legal assessment, it's also an assessment that you make in terms of, for instance, where are most of your data going? And that will be different from country to country. So one country will think my most important trading partner, trade involving very often in today's world, the exchange of personal data is country X, and it will be country Y for another one, and that's why you might choose to have an adequacy dialogue with different countries. So in that sense, I think it's natural that there is no full overlap. As you know, it can create issues because of the issue of onward transfers. At least we, in our assessment, not just for adequacy, but also for other tools, one of the guiding principles is trying to, at least, and there are limits to as far as you can go, but to ensure the continuity of protection from sort of the transferring entity to the next entity and then afterwards. And of course, if the standards are very different, were to be very different that countries apply when making adequacy findings, then that can create issues, because then there might be a clash between one country wanting to open the gates to another country. and another one sending data there and then being worried that this is done too easily. And that's the onward transfer issue. So there are solutions to that. We have found them in the past. We had the situation, and then we had to find additional safeguards for those situations. It's not ideal, I would say. Of course, the best would be to have the same standards for adequacy, and of course to have convergence of data protection regimes in general. I think, and I think that applies across the board. It's the best way forward to facilitate flows. So we should work on that.
Joe, I see you looking to jump in there. Your thoughts on this one?
Yes, thanks, Caitlin. 3 points, two that really agree with Ralph, and then my third, just to pick up on your concern, Caitlin. So adequacy is an incredibly important mechanism. And we hear time and time again how really governments and policymakers need to step in and provide that clarity and that certainty, and what is, quite frankly, quite a blunt instrument for organizations. They need look no further than the list of jurisdictions that government has compiled to say, yes, I can transfer data there and it's safe. They need not implement other mechanisms. So that's the first point. And it's important we get moving on that. I think we do need to scale up because the world is moving. There are countries that are coming online with comprehensive data privacy laws, and governments need to react and respond to that. The second is on Ralph's point. Adequacy is a really important way to begin that conversation around data protection standards between jurisdictions. I think it's incredibly important that those partners, when they're having those discussions, are humble and cooperative, and it's a very bilateral discussion. There's a lot that jurisdictions can learn from one another. And I think if you approach those discussions by focusing on the outcomes, rather than exporting or looking for your standards to be mirrored in another jurisdiction, then you can have a much richer, more vibrant conversation. In fact, you could even learn from how other countries do things and bring the elements and some of the principles of that into your own framework. I think the panel after this will include a discussion on UK data protection reform. We've been casting the net far and wide across the world, sometimes through our adequacy discussions, to learn about how other jurisdictions do things, the Canadians, the Singaporeans. So that's the second point. I do, on my third, agree with your concern, Caitlin. I think there is a risk that we miss an opportunity here to leverage not just the economies of scale, but to leverage, frankly, the smarts that exist around the world in this area. Right? There are countries, jurisdictions, that are going about their business in an incredibly intelligent way. They are doing so with a lot of scale, and they are doing so diplomatically, and they're getting on with things. And we could learn from that, to my second point. As you said, there are countries that have drawn up a list, a white list, green list, adequacy list, themselves of over 50 countries. The UK doesn't have that. The European Commission doesn't have that. We could learn from how they did that. We could look to replicate it, to Ralph's point. But there is a risk that this becomes, I think as someone said a few weeks ago, a bit of a geopolitical beauty parade, that we're all competing with each other, that we all say, well, I got there first, we've done our deal first, when actually the opportunity is to get to the table and say, look, we have found this country to meet our standards. There's no point you replicating, copying that exercise. We've done it by the same laws, by the same principles that we share. So let's try and add more scale by working together. And I think some of the multilateral conversations are really important and exciting for this.
Well, thank you. I like that. Geopolitical beauty parade. Did I get that right? That's my takeaway so far. Well, Joe, I wanted to follow up on that then. I know the UK is looking to reform both its approach to the UK GDPR and its data transfer approach writ large. Is there anything that you would add to what you've just said in terms of how you think or what you think would need to change to make this landscape work more effectively?
I think taking the heat out of some of the discussion would help. I think at the moment, these issues and these conversations can be viewed as, well, you're not good enough for us, or you need to do something else to be good enough, or to be adequate, or to be equivalent. And actually, going back to my points earlier, it really is about the outcomes. Different jurisdictions, different countries will do things differently in form and in means, because privacy is, after all, something that reflects our cultural DNA. Right? The way that countries approach these issues reflect their constitutions, their traditions. In the UK's case, that goes back centuries. It goes back to how our constitution's not neatly coordinated in one place. That's quite different to the United States. It would be a lot easier if we did have a tick box approach, because the exercise would be easier, but we would be finding far fewer jurisdictions adequate or equivalent. So we have got to get beyond that veil of difference and work hard with our partners, with the experts, with the industry and organizations on the ground, to have that conversation around, well, the rules look different to us, but in practice, are the same things being achieved in outcome. And oftentimes that is the case.
Well, thank you. I appreciate that. Kathy, I want to bring you into the conversation. I think most folks in the room probably know that the U.S. has traditionally approached these issues differently and not placed rules on international data transfers, but rather encouraged open data flows as a general matter. At the same time, as I just teed up, over the last 2 decades, we've seen a lot more restrictions internationally on data transfers. Does the U.S., from a policy perspective, think that these should be rolled back, that we should pursue more multilateral mechanisms or bilateral or contractual approaches to move data? What is the U.S. policy goals or approach here?
Well, first, I want to correct a misconception. The U.S. does have laws around privacy and data protection. Imagine that. So there are certain sectors that have very stringent laws, like the finance sector, the health sector, education, and those laws apply and will apply to the data being handled by the organizations that are covered. So there is an impact then on transfer for an organization to be in compliance with the laws that do apply. So just to, correct that rumor. I know that we're all talking about these different multilateral forums, and I do think that one thing that all of these privacy conversations is showing us is that there are commonalities between different frameworks that have been developed by democratic rule of law states. So with these commonalities, there are common principles in some instances. Otherwise, there's actual commonalities of what's happening to the data on the ground. We can build from that in the multilateral forums. I had mentioned the G7, the G20, OECD has an initiative I'm sure we'll talk more about, Trusted Government Access, that was led by Japan initially, so it's a terrific initiative. There are also frameworks that have been developed internationally that do set really, really strong standards and also have the adaptability that recognize different legal, historical, and cultural traditions. For example, the Budapest Convention, the Cybercrime Convention. The second additional protocol was just open for signature a few weeks ago. And the protocol encourages and enhances, facilitates international cooperation in the criminal law enforcement context, cybercrime, and also electronic evidence sharing between authorities in different countries. It also includes an article that has very rigid data privacy standards, but it focuses on the outcomes of how the data is being handled and managed, sort of on the ground, what's happening on the ground, so that the controls in the second initial protocol are designed to be effective on the ground in practice. So I think it's a really good model. It does give countries the flexibility in how they implement those controls to reflect their own traditions, legal, historical, and cultural traditions. So in terms of multilateral arrangements on privacy, we just need to keep working on those commonalities and also make sure that as we're developing these frameworks, there's enough ability for, particularly for younger countries, younger democracies, to be able to adapt the standards to their own traditions. And I'm sure we'll get into the CBPR, Global CBPR program, Cross-Border Privacy Rules Program, so we'll talk more about that in a few minutes.
Sounds good. Well, and I like that you raised the Budapest Convention, because at least from an outsider's perspective, and Ralph, I think you've worked on this one as well, if I'm not wrong, but it does seem that has been a little bit less of a geopolitical beauty contest, so perhaps lessons there. I didn't know if you wanted to...
Not to the outside, maybe, but... it was a difficult negotiation, but a successful one, and so I think that's, talking about outcomes, I think that's what's the important thing. It is possible, even among a group of countries which maybe don't always agree on everything and indeed come from different backgrounds and traditions to come up with something which indeed I see as a model for data protection in that area. So it's fantastic, especially if you think that this convention has 70 something state parties. So it's, I mean, in one go, it's not bad.
A little more global. Okay, so I'm going to
I just want to point out, in terms of the signatures, 22 countries signed on to it the first day that it was open for signature. So it is going to really strengthen privacy around the world in the context of law enforcement data transfers, and also enhance cooperation and exchange of evidence in those cases.
But if I can just add, I mean, because I've heard a lot about outcomes and we should focus on that. And I mean, I generally agree with this. I mean, if you think about what the first Schrems judgment said, it was that. The Court of Justice said the standard is essentially equivalence, so for adequacy. But that doesn't mean you have to have the same mechanisms. You don't have to have the same ways of doing it. What counts, in a way, the court said, is the outcome. But then I think there's just maybe a footnote to that. I mean, of course, the devil is in details. So you have to then also see at which level you define the outcome. I mean, how broadly, what is it, the level that you can agree on? And if it's very broad, how can you ensure and verify that sort of what you have in mind with that outcome is sort of convergent with what the other side wants? So I mean, I think when you then actually look at these things, it's a bit more complicated. I mean, I agree. One has to, and we always do that. You have to respect that every country has its own political, social, legal traditions and background. And you have to work around that and try to find ways to bridge that difference that might exist. And you have to do that with full respect for the other side. But at the same time, of course, in an area which at least here is I mean, it's a fundamental right, we also need to be sure that the outcome is of a certain sort in law and in practice. So just a little caveat here that I mean, sometimes maybe you also need mechanisms to then follow up on a broad agreement to make sure that really in practice it gets you where you want to get.
Well, you know, let's get into some of those more contentious systems, because that's where the fun and the challenge is then, right? So I'm going to dive into some of that, but I'd love to not really wait to the end for questions also. So I'll keep looking to the audience. If you all have questions, I'm happy to feed them in as we go. So feel free just to raise your hand. So Hiroshi, on that point, I want to come to you. One of the things now that has been raised and has been, to some extent, a point of contention in the past is the Apec cross-border privacy rules system. Japan and Canada both have adequacy determinations. Japan's is a mutual adequacy determination negotiated in the context of a trade agreement. And Japan also participates in the Apec cross-border privacy rules system. This is novel. Maybe there's something we can learn here. You know, what can we take away from that? How can these two approaches work together?
Well, thank you, Catherine. That is the most important question in the Japan's adequacy decision, in my understanding. But I have never seen a perfect answer on this matter so far. If you look at the paragraph 79 of the Japan's adequacy decision, in this paragraph, explicitly prohibits to use the Apec CBPR as an onward data transfer tool. So we can't rely on Apec CBPR once the data is coming from the European Union. So most of the Japanese companies have trouble in, making global data transfer based on this Japan's adequacy decision. And that's why the PPC, Japan's Personal Information Protection Commission, published a survey report just a few months ago, recently how the Japanese global companies has been addressing these data flows, data coming from the EU, how can they mitigate the risk, remove the risk, and then retransfer, onward transfer to other region based on the adequacy decision, based on the PPC guidelines, the Personal Information Protection Commission's guidelines. So they face these dilemmas on data transfer and onward transfer. So they have the data from the EU on the one hand, on the other hand, they have the data from the US and the Asian neighborhood. So therefore, our government has been promoting the data transfer, data free flow with trust with non-EU countries, with an aiming of realizing global data transfer, but with a high degree of trust in protecting personal data.
So that's interesting and perhaps quite relevant to our conversation. Can you tell me, or tell us, please, any more about the Data Free Flows with Trust initiative then? What is it? Why should we look to that as part of the solution?
Yes, thank you. DFFT, Data Free Flow with Trust, first came out on 23rd January 2019, very much on the day of adequacy decision. So then Prime Minister Abe delivered his speech at the Davos World Economic Forum, and data free flow with trust. We already shake hands with the EU, but we have to shake hands with other regions, with US and Asia and the rest of the world. So DFFT means we must put our personal data and data such as intellectual property or national security intelligence under careful protection. But on the other hand, at the same time, non-personal data, anonymous data, or the other important data such as industrial traffic data must be shared without borders. So this is a Japanese way of DFFT initiatives. So the recent, the government data strategy clarifies DFFT at least with two important components. First, DFFT is against unreasonable data localization. Second, DFFT is against mass surveillance without transparency and remedies. That's why the Japanese government has been pushing the trusted government access to private data under the OECD forum.
Thank you. That's helpful. All right, so I want to talk about one new initiative that is recently launched that is designed to, I think, get at this more global challenge. And that is the new Global CBPR Forum, which was recently announced by quite a number of countries. And then the US hosted the first meeting of the new Global CBPR Forum. Japan was an early adopter, as we said, and leader in the development of CBPRs within Apec. The UK has expressed interest in the new Global CBPR Forum, and the EU has alternately engaged with interoperability with BCRs and suggested that this is a lacking framework. So Kathy, before we get into those different dimensions there, can you give us a quick overview of what the Global CBPR Forum is? You know, how the US thinks it could scale, and perhaps, if you can get into it, whether substantive changes will be needed compared to the Apec version when we think about scaling.
Thank you. Let me say a couple of things about the current CBPR Apec cross-border privacy rules framework. It really is an effective, scalable model that's worked well in Apec. It is a real practical approach to data transfers. The focus is really on having program requirements that companies can certify to, that they're compliant with, and then the companies are audited, basically. There are accountability agents that go through and actually review how the data is actually being handled and whether the data is being handled in ways consistent with those program requirements. There also are enforceability mechanisms. The program requirements are government-backed, so the governments are involved in making sure that they're developed and launched and implemented the correct way. So the Global CBPR Forum is a group of countries that have come together to probably take another look at the current program requirements because they need to be reviewed regularly anyway. But the forum's goal really is to promote interoperability of data protection privacy frameworks to really make sure that there is some sort of a framework like CBPR that holds companies accountable to what's actually happening on the ground, what are the outcomes with the data and how the requirements are implemented, and are enforceable. Because CBPR, because of the real focus on the accountability and enforcement mechanisms, it really is going to be a scalable program. So the countries involved are really trying to push for this sort of interoperability. And CBPRs are one tool that an organization can use. The EU will look at the CBPRs as a tool in whichever way it prefers to do so. I mean, it sets high standards for privacy, data protection, and those program requirements are assessed regularly by the third-party accountability agents, and they're enforceable.
So I'm going to put you on the spot here, and if you don't have immediate answers, that is all right. Can you tell us which countries are current participants? Can you tell us which additional countries gathered in Hawaii to, I don't know, express interest in this system? Do you have any of that?
Yes, I have some of that detail, thank you. So currently participating in the CBPR system with the Global Forum countries would be Canada, Japan, Republic of Korea, Philippines, Singapore, Chinese Taipei, and the United States. And I believe there were a few additional countries that were participating in the discussions in Hawaii recently.
Yeah, perhaps Joe can help.
From the UK, he can add to that. But it was a really successful meeting, and I think the forum launched well, and I think that it really is in a good place to set up an effective, scalable system.
All right, Joe, I'm going to turn to you then for the additional, but I'll throw a little bit more at you. I'd love to hear about the UK's interest, maybe if you know who else is interested. But I think trying to get to the point of contention here, the CBPR system is often pitted in the press as an alternative to the European model. Do you see it as an alternative or something that could be additive here? Do you see how do you see the UK engaging? And Ralph, I'll give you a chance to jump in here after.
So I think it's additive, for now at least. And I think to Ralph's point earlier, it's got to be another tool in the box. And look, the UK congratulates the initiative and the leadership of those economies that have taken a system that was in the Apec group, spun it out, and humbly said, let's look at this again. Let's look at the requirements. Let's look at the participating economies and ask ourselves, is this right? Can we improve upon it, and can we bring others to the table? So that's got to be welcomed. The UK is taking a very active interest in that. I think as a European nation with a very long-standing history of privacy and data protection, longer than the GDPR and the directive, we can bring that to the table. But given the diversity and variety of jurisdictions at that table, and the diversity and variety of the approaches they take to these issues, it is not going to be right to say, this approach is the one approach we must all take. And that's what's great about the CBPR scheme, that it's taking that organization-led, driven approach. There's accountability. We're used to that in Europe with the BCRs, where organizations and regulators really look at what happens on the ground. There's been a BCR CBPR referential. There have been organizations that have bridged those differences. So why can't we do it at a national level? So I think there's going to be a few weeks and months of quite important, interesting and exciting discussions amongst those economies, and it's great that there are others outside of APEC that are leaning into that opportunity.
Well, thanks. I'm going to stick with you for a moment. We've got questions. Okay, I will turn. I want to see if I can get two quick answers from Joe, and then I will turn to the audience and come back here. Can you say anything about who else might be interested in joining this? Other countries?
I think I can, because I think some of that is public. The Brazilians were there. There are some free zones in the Middle East that were there. Some other Latin American countries, Chile, Colombia. So there, as I say, there is that variety of interest. Some of those jurisdictions take a sort of GDPR-like approach to their own regulations. They have, as you pointed out, Caitlin, at the beginning, introduced into their legislation adequacy-type powers. Some of those other jurisdictions take very different approaches in terms of form. Certification is something that is not so familiar to a UK, European regulatory landscape. It is quite familiar to Singaporeans. The South Koreans are more used to it. So we have a lot of learning to do here, I think, to better understand how the CBPRs could fit, could work, could be a more scalable solution. There is nobody at that table that's saying this is the perfect solution, that this is the only solution, that this is better in competition with the EU, the UK approach. Nobody is having that sort of dialogue. Indeed, everyone is saying this could be another thing that will be helpful. This is why the European Commission, the EDPB, the UK, the ICO, we're thinking about all the other tools. New contractual clauses. How do we have those contractual clauses speak to, work with other mechanisms? How do we encourage that network effect on adequacy? The conversation on the CBPRs is very similar.
Well, thank you. So I saw a lot of hands, and I don't know whether it was this conversation that, so yes, please, jump in.
Hi, Javier Ruiz. I'm a digital rights consultant. I just had a question whether CBPR is actually a bit of a red herring in terms of comparison with adequacy, because as we understand it in Europe, which may not be, which we actually don't fully understand it, it seems to be quite a convoluted process that would really only be possible for very large companies. So I wonder whether actually we should be looking at it more as an alternative to BCRs or something, that only large multinational corporations can do, because I cannot imagine how a tiny two-person company is going to go around engaging all these privacy people and paying for all these assessments. So I think that may be a bit of a, I don't know if that's a fair comparison. And the second point is I would like to understand a bit, particularly for Joe, how we see adequacy playing with digital trade agreements when we put rules that say that we must have the free flow of data and that anything that is excessive or an excessive barrier to trade basically could be in breach. So I think and I've talked to some people from DCMS and they say that they think that is not a problem for the UK to be signing trade agreements with Australia, for example. That is not an adequacy country. And so I would like to see if you could explain how that works.
I love that question because actually I wanted to pose a related one, and so I'll just loop that in. For those less familiar with the Apec CBPR system, it hasn't scaled particularly fast at the company level. So let me just bolster on to that. Could this one scale faster? Why? Or is it more designed for large companies? Joe, do you want to take that?
Well, I think it hasn't scaled because it hasn't needed to. I mean, when it was first introduced, the jurisdictions that were participating did not have cross-border data transfer restrictions. Many of them didn't. Many of them actually still don't. So what was the incentive to join a scheme that facilitated cross-border data transfers when you didn't really need to join that scheme? Now, times are changing. Those jurisdictions, as Caitlin has pointed out, are actually introducing restrictions because it's important to protect their citizens' data, not just at home, but when it's transferred. So there's a demand-supply question there. There's also a question of trust. Now, organizations and jurisdictions are clamoring to demonstrate trust, right? They're looking for ways to visibly demonstrate that trust. Seals, marks, public lists all go a long way to doing that. The 5,000 plus organizations that were certified to the Privacy Shield would say that they certified to the Privacy Shield, not just because they had to, but because it was an important mark of trust. Organizations and consumers that were dealing with those businesses knew that their data would be protected according to certain rules and practices. May I address the question on trade? And I think it's a really good question, especially where you have a government like the UK government that's very busy on both fronts. Right? We're concluding trade agreements, and we're also busy negotiating and discussing and implementing mechanisms for personal data transfers. The two are legally distinct and separate. The way I like to think about it is that the trade agreements are all about market access. And if you're a plumber, the trade agreements are around putting in the pipes, right? Making sure there are the conditions for trade to exist. The discussion on and the work on personal data transfers are whether or not you turn the taps on and what conditions you need to exist before you turn the taps on. Adequacy, the adequacy tab, will enable lots of data to flow more confidently. There's more certainty, but you ask yourself more questions on whether and how you turn that tap on. So we don't see the trade agreements as something that enable legally, or as a legal basis, the free flow of personal data. It's something that puts in place the conditions around data localization, common standards and frameworks. And I hope that answers your question.
The question was the opposite, is whether trade agreements can actually stop certain mechanisms like adequacy, because they are seen as too high and complicated.
I see the point. I don't think we would ever view a trade agreement as something that would put in place barriers or preclude initiatives and innovations that would seek to reduce or remove barriers.
So, Ralph, I want to come back to you before we leave the topic of CBPRs, because I know, if I can just be very open about it, you've been openly critical of the system, but at different junctures, the EU, as we've discussed, has engaged in interoperability talks as it relates to CBPRs, BCRs. How do you view this? Do you think it's the new system, the global CBPR system, is one that the EU would engage with?
I mean, first of all, and I think I'm learning new things here. We don't know yet so much about it. Is it a name change? Is it has APEC been replaced with global, or is it something which has changed or will change on substance? As you know, certification is a tool for transfers under the GDPR. It's something which we certainly want to develop, and I would readily admit that we have been a bit slow in that. We will soon, I think, see the guidelines on certification from the European Data Protection Board, and that will, I think, make certification operational as a transfer tool in the EU, from the EU. So certainly that's something we're interested in, and we see it as a part of the toolbox. I think, and on that I agree with the colleague that had asked the question, that CBPR, not CBPR, certification has its limits, I think, in terms of it's company by company. There's two ways about it. You can either have a very light certification system, then maybe it's not so costly and doesn't take so much time, but then maybe it's also not so protective. Or you have something where there's a really bite to it and a real strong auditing process and monitoring process afterwards. And then I think it takes time up front and then later on, and it has some cost. And there's a question mark around that, and that's a question mark also about our own certification system, what it can do for small and medium-sized companies. And those are certainly here in Europe the backbone of the economy, and I think that's true for many other parts of the world. So there's that question, but that doesn't mean it cannot be a part of the toolbox. And so, of course, we are always ready to engage with international partners. I think it would be important to see sort of what's changing, because we, indeed, as you pointed out, we have had in the past concerns or questions around the strengths of APEC CBPR in terms of the standards, in terms of enforcement. I think there have been zero almost enforcement actions in something like 10 years. It's of course also a very small number of companies. It was mentioned that it hasn't scaled up. Indeed, I think we have currently 42 companies after something more than 10 years. And I think 36 are in the US, and then I think it's 3 Japanese and 3 Singaporean. So I guess one cannot say it has really scaled up. And that might also mean that therefore we haven't seen so much enforcement. But that's something which we certainly are concerned about. Because of the fact that it hasn't scaled up, I'm not quite sure I can follow Hiroshi's comment that it has created such big problems for Japanese companies that have adequacy or that receive data from Europe under adequacy, because it would really surprise me if they're the ones that absolutely wanted to transfer to these 36 other companies around the world, and that created the major problem. So I don't think that's actually fully correct. But we certainly we are ready to look at that, and we do this with an open mind. And if it can be strengthened, and we will certainly look at this from the or through the prism of also the guidelines that I said are being developed, to see, is that something that could also be recognized in Europe? I mean, it's a possibility, but I think it needs to be seen sort of how it develops and the strengths that it will have. I mean, the idea is, of course, there that I mean, because I think the certification model that we will have will probably require that there's a certain link in terms of the certification bodies to Europe also, so that there's a bit of a check on what's happening. If it's a model where you completely rely on the auditing and monitoring of foreign system partners, of accountability agents, the trust that Joe mentioned will become crucial. So that's I think where you will probably see the discussions. How can we ensure that trust? And I think Joe is also right that now that more and more countries around the world have transfer regimes and require safeguards for transfers, it is now becoming all the more important that a transfer tool really ensures that continuity of protection. So all of this to say, it's interesting. We will follow it with interest, and we're certainly happy to talk about it. And then what matters is the substance.
Thank you. Hiroshi, I didn't know if you wanted to clarify anything there. Otherwise, I can go to another question.
Well, as Ralph mentioned, Japan has been contributing Apec CBPR, but only limited 3 companies has been a part of the Apec CB program so far. So most of the global companies have hesitation whether to join Apec umbrella, or we need to strengthen more tie with the EU adequacy umbrella. So this is a dilemma for the Japanese global companies.
Yeah, perhaps points to the point you made, Joe, about what are the benefits, and if it doesn't offer the benefits, especially in terms of jurisdiction to jurisdiction, then why join? So, Ralph, I want to come back to you. You know, you've talked about, we've talked about different approaches to scale. You know, adequacy determinations, at least in the EU, remain somewhat limited in terms of the numbers so far. Obviously, they take some time to negotiate. So is contractual arrangements, standard contracts, I know you've led on the development of the new ones, are those the EU's kind of best or desired approach to scale this more broadly, and how do you think they are functioning right now?
Again, I mean, it's part of the toolbox. I think it's a very important part of the toolbox. It's always difficult to get numbers on this, but to the extent trade associations and other I mean, research organizations have tried to gauge sort of what is the amount of data flows under which tools. We have seen numbers in the range of 80–85% of data transfers from the EU are based on model clauses. So clearly it's something that the market considers an important transfer instrument, and I can understand why, because if they work well, they are an easy-to-use tool. They're ready-made. It's a model contract that's pre-approved, so you don't have to. You actually cannot negotiate it, at least on that part, the data protection safeguards. But that relieves you of the need to, I don't know, engage a lawyer. I mean, there's annexes that you have to fill in. Yes, there's certain things to be done. You have to describe your transfers. But in principle, you're not engaged in a negotiation because it's pre-approved. So in that sense, it's a tool which I think can reduce costs and is useful, in particular for small and medium-sized companies. And I think it can be a strong tool because there are clear rules in terms of submission to the jurisdiction of a data protection authority, a supervisory authority, in terms of redress, enforceable rights. It creates what we call third-party beneficiary rights for individuals, although it's a contractual tool, so there's a call data subjects, so the individual whose data is transferred, can invoke the agreement. So I think it's both an effective tool, I believe, and it's one that is affordable for companies. So I definitely think that it's something that has the potential to become a global instrument. And again, you also see that we are not the only ones that have developed model clauses. Actually, before we modernized our model clauses, ASEAN had put into place model clauses, and then the Ibero-American Data Protection Network has created a set of, or two sets of model clauses for the entire Latin American region. So that's not small. I mean, those are three big regions of the world which have endorsed this tool, and then a number of countries have done so. There are differences. I would say there are bigger differences between, let's say, EU and the Latin American one on the one side, and then the ASEAN one on the other side. But for instance, between the EU model clauses and the Latin American ones, they are not far apart. The Council of Europe, now under Convention 108, is also developing model clauses, and that will cover additional countries, also in Africa. So I think if there was a way to narrow the differences between those, I think it is a scalable tool. And so I believe that together with adequacy, those are, for us, probably the two most important tools that I see going forward, yeah.
All right. Questions, I love it. Right here?
Hi, sorry, I'm Julian Jemison from Ava Pharma Group. Just in relation to reducing costs and the use of the SCCs. So I suppose I was glad to see new SCCs come in. I was not so glad when I had to start doing assessments of the other countries and the legal framework there. I'm a lawyer, but the pushback I'm getting in a small company of 500 people for the administrative cost of that, you're talking about hiring more lawyers. So I see a real problem for small to medium-sized countries where we have huge international data transfers under pharmacovigilance law for companies like pharmaceuticals. So I don't see it as a tool that suits my company at all.
No, I understand that part, and it's. I mean, I don't want to say that that's something which is not necessarily of our choosing, that there is this requirement that we have from our case law following the Schrems II judgment to add on to the sort of commercial safeguards the need to check what's the situation in a third country in terms of government access and to what extent can that interfere with the data importer ensuring the protections that it contractually commits to. But that's not something that necessarily other countries have to do it that way. And you see there is, I think, a lighter version of that, for instance, in the Latin American model clauses. It's at the same time not something which just we do, so it's also not just an EU obsession. I mean, I've seen the New Zealand model clauses, they also have something on government access. But it doesn't have to be maybe in the same way. It has to be on our side because that's a requirement that comes from our highest court. How one applies that, maybe there's also a bit of space, and you might know that as Commission we have pushed for giving more space to companies in terms of having an element of risk assessment in there. So it's true that this is a part where cost would be created. I just don't think that this is something. I mean, if we think about a global instrument, that's something where necessarily everyone has to go the same way, and because the focus should first of all, of course, be on how the parties protect the data exporter and the data importer. I think there's a need to also have transparency around government access, and maybe to some extent also a need to at least point to obvious problems that might exist in a third country. Whether you have to go as far as the Court of Justice requires us to do under Schrems II is maybe another question for other countries. So that's why I still think that it is a tool that can be developed in a way that it is effective and cheap and ready-made, and doesn't require a lot of add-on in terms of assessments or notifications. So I think basically you have to distinguish a bit maybe between the legal framework in which we operate, constitutional framework as interpreted by our highest court, and the tool as such and how it can maybe be used.
All right,
So just to say, so it's like a risk assessment of the risk assessment then, essentially. I'm good with that.
If you want to call it that way. No, it's just that of course, as I think the discussions previously on the DFFT, for instance, have shown, government access is a concern not just for us. It is a concern increasingly around the world, which has found its expression, I think, in a very good way in the DFFT and the work of the OECD, but also what many countries around the world are doing, the US, Japan, in terms of protecting certain data from potential interference by malicious third country actors. So it's probably not something which will go away even globally, and we need to find ways, I think, to create that trust, and that's what the work at the OECD, for instance, is about. But whether it necessarily for other countries around the world has to be in the way it has been set out in a judgment from a European court, I think that's another thing. And I think there is a space.
So let's address that quickly, because I feel like that's the elephant in the room, right? We can probably all solve these commercial challenges, but that's not what's created all the problem here. It's the government access issues. So can we...
Which, by the way, you could also have, of course, for any of the other tools. I mean, we have it for adequacy, you can have it for certification.
Exactly.
If you care about this, the same type of assessment will have to come in for any of the other tools.
Yeah, so can we solve this on, in 10 minutes? On a multilateral basis. Can we have a multilateral treaty? Can we have a multilateral instrument in the OECD? Kathy, I know you've worked on the OECD government access. Any thoughts here on how we solve this huge challenge?
So I have to go back for just a second to Privacy Shield.
It's forbidden. It was ruled out. It was mentioned twice at the beginning.
So one thing to keep in mind is that with Russia's invasion of Ukraine, that has demonstrated in a really personal, person-person level, the importance of information sharing between government agencies for law enforcement and national security purposes. I will say that I read an article in the paper about German intelligence authorities obtaining data from Russian soldiers that they're going to be able to use to prove that those soldiers committed war crimes. So the data needs to be used by government authorities within an appropriate data protection privacy framework. I'm assuming that German intelligence followed the law in Germany. So the data needs to be transferred for really important purposes. These are not theoretical issues. Oh, gosh. Okay. So anyway, these are not theoretical issues. This really impacts people. With regard to Privacy Shield, there has been an agreement in principle on a better, stronger framework that provides stronger safeguards and also a binding redress mechanism. We are still working out some of the details on that in writing with the Commission, but there has been an agreement on principle. OECD, I think, has a lot of potential. And the most important aspect of the OECD Trusted Government Access Initiative is that the law enforcement national security folks are at the table in those discussions and negotiations. And that is actually, I think, what was most useful in the Budapest Convention protocol negotiations. Law enforcement experts about how the data needs to be used, what data is necessary to fulfill a particular purpose that needs to be fulfilled in the law enforcement context. You have to have those experts at the table. So I do think that OECD has a lot of potential. I think that the initiative could really move forward in a positive way.
Let's hope then. All right, I see a question up here in the blue shirt, please.
Debray Kennedy Mayo from Georgia Tech in the US. And to Catherine's earlier point, I am also the co-author of a textbook of US private sector privacy law that's about 350 pages, and we're then criticized for being too complex. So just to move, though, to China. I know that there was talk about the EU adequacy decisions, and they would focus on important trading partners. In the media during the pandemic, it was reported that the EU's leading trading partner was China. And so with the standard of necessary and proportionate in a democratic society, I'm curious to hear your thoughts there. There's been at least one report from the EU that has said, as to third countries such as China, that in a democratic society is going to create a real problem with any adequacy decision. But there have been others that have said perhaps China could get an adequacy decision. So I'd love to hear your thoughts. Thank you.
I mean, we're not in adequacy talks with China. I mean, but that's probably not what you're suggesting. I mean, neither have we received a request on that, and we certainly are not assessing anything in the context of an adequacy dialogue with respect to China. So, I mean, I'm a government representative, so I'm diplomatic here. But I think one could say that probably would not be an easy assessment. Let's say. So I don't know. Of course, China, I think we all know what the situation is, and I think it's that there are risks for data, and that should concern us all in terms of data transfers. I think China is probably the most important trading partner for almost anyone, or one of the most important, maybe not the most, but among the top 3 or 4. So we all transfer data to China, and we all have investment of China into our companies, and they transfer data back to headquarters in China. So yeah, that's I think why we have the process of, for instance, at the OECD, but also in other fora, for instance, in the Council of Europe, and there was also the Global Privacy Assembly, to develop global principles for proportionate, I would say, government access, and to show sort of what we as like-minded countries believe in and expect from each other. And what might distinguish us from certain other countries, and what we want to push for also with respect to those countries. So I don't know what, but so I can reassure you at least we're not in adequacy talks.
Do we have another question there? Yes, the gentleman right over here.
Thank you very much. Thank you for your presentations. My question concerns the application of ACCs in the practical world. So, as I understand, the ACC need an application between both 2 companies. So, one company in the EU, for example, another company, let's say in the USA. So, you already know that the company has not the same power. So, let's say, for example, a company in USA doesn't want to, to apply the SSA, the EU SSA modules and provide his own SSA. How to deal with that? How the Commission position itself on those situations? I really need to hear your opinion on that. Thank you.
So I mean, thank you for the question, because I think that's probably worth clarifying. I mean, it's a voluntary instrument, no? I mean, it's not that ACCs, anybody has to use them. It's an instrument that we provide, that we offer, and that can be used by companies if indeed the 2 sides can agree to incorporate that into their commercial contract. If they don't, the data exporter, because I mean the obligations are not on the importer, but it's the data exporter. When we talk about the EU, that has to think about, is there a way that I can transfer data in line with the requirements of our EU data protection framework? And if it's not model clauses, then they will have to look for something else. If there's an adequacy finding, they can rely on this. So that might soon be again the case, for instance, with respect to the US. You mentioned a US company. And then there's BCRs, and then there can also be individual contracts that are sort of tailor-made and negotiated, but then need approval. And there are certain statutory grounds for transfers, which are actually also quite important, and our law at least, for the fulfillment of a contract or based on consent or other grounds. So it's not, I mean, that's what I meant. There is, the important thing is that we have a flexible toolbox where different tools have different strengths and weaknesses perhaps, and they can be used in different contexts. But you need to rely on one of them, at least when it comes to transfer from the EU.
And coffee beckons. So I wish we could have solved this. I don't think we did. Please join me in thanking them and ask them over the coffee break.